A very warm welcome to all of you. I'm Professor Jennifer Davidson, the Executive Director of the Institute for Inspiring Children's Futures at the University of Strathclyde. And on behalf of the university, I'm delighted to welcome all of you to the 19th Kilbrandon Lecture. Yet again, we are together from our homes or from our various personal spaces, possibly eating your dinner as you watch, possibly in your slippers. Sadly, this is yet again the circumstances for our year, but we're really glad that you've joined us. This is such an important moment in our gathering together and our concerns for children in Scotland and around the world. And thank you for joining us yet again for the Kilbrandon Lecture. I'd like to just ask you to sit back and relax. Let me share with you some housekeeping notes. So the first is, let me tell you about the evening. In recognition of the online platform, following our Kilbrandon speakers lecture, instead of questions, we will be inviting two respondents to reflect on the lecture, and then our speaker will in turn respond. And you'll see that there isn't a chat function in the Kilbrandon lecture, but your comments can be captured in the question and answer section. And those questions and answers will come to the panel. So this isn't for your questions per se, but it's a space for your reflections. And our speaker, Claire Lighthowler, will draw on those reflections for her feedback about what she said on the lecture and for her closing remarks. We will close with the Minister for Children and Young People, which is a pleasure for us to have her with us. Given the sensitive nature of the content of our Kilbrandon lecture, particularly this year, and in recognition of this isolated nature that we're all attending today, we're sharing the contact details in the chat at the moment for support, in case you might like to be reminded that, that we are not all alone as we watch this lecture together. And on that note, I am really delighted to ask Professor Sir Jim MacDonald, Principal and Vice Chancellor, to formally open the evening and to introduce this year's speaker, Claire Lighthowler.
Thank you, Jennifer, and good evening to Minister Haughey, to our distinguished guests and all those joining us this evening. It gives me great pleasure to welcome you to the 19th Kilbrandon Lecture. And I'm delighted that we're able to welcome Dr. Claire Lighthowler, former Director of the Centre for Youth and Criminal Justice here at Strathclyde. And I look forward to hearing Claire's contribution to this well-established lecture series. There have been many distinguished lecturers since this series was inaugurated, including Donald Dewar, the First Minister of our Scottish Parliament, and more recently, Nicola Sturgeon, First Minister. We've had Sir Harry Burns, Scotland's former Chief Medical Officer and now Professor of Global Public Health here at Strathclyde, Professor Alexis Jay, who is an Honorary Professor at Strathclyde's Centre for Excellence for Children's Care and Protection, and who continues to chair the independent inquiry into child abuse in England. We have Professor Kathleen Marshall, Scotland's first Children's Commissioner and Chair of the Institute for Inspiring Children's Future, who I'm delighted to say is also with us this evening. And last year, we had the opportunity to hear from Madeleine Bunting in her lecture, Labours of Love, the Crisis of Care. As many of you will already know, the committee, which Lord Kilbrandon established in the 1960, led to the formation of Scotland's unique and globally respected approach to care and justice for young people, the Children's Hearing System. And the hearing system is designed to ensure that children's needs as well as their deeds are considered whenever legal proceedings relating to care and justice concerning children arise. Since its inception, the system has contributed immensely to the care of children and to greater respect for their rights and their futures. The Kilbrandon Lecture Series is a joint venture between the Scottish Government and the University of Strathclyde. The lecture, which was initiated by the University of Glasgow's Centre for the Child and Society, is now hosted by Strathclyde School of Social Work and Social Policy. And I'm delighted that Malcolm Hill, Professor Emeritus at Strathclyde, who worked alongside Professor Stuart Asquith, who founded the Kilbrandon Lecture Series in 1991, is also in attendance this evening. And I'm pleased that Scotland's Minister for Children and Young People, Claire Haughey, who will deliver the vote of thanks this evening, has joined us too. It's very encouraging to note that the lecture continues to enjoy the support of Lord Colbrandon's family. And Professor Jennifer Davidson, who you've heard from, Executive Director of the Institute for Inspiring Children's Future, has agreed to chair the question and answer session following the lecture. It's also a privilege to have with us Elliot Jackson, Chief Executive Officer of Children's Hearing Scotland and National Convener of the Children's Panel. Joe Griffin, Director General of Education and Justice with the Scottish Government. And I'm also pleased to welcome Michael Chalmers, Director of Children and Families with the Scottish Government. And we're also joined by representatives from local government and the voluntary sector, the Scottish Government, and academic colleagues from across Scotland. And we're particularly delighted to have in tonight's audience individuals actively engaged in the lives of children and young people in Scotland, panel members, social workers, healthcare workers, teachers, members of the legal profession, and most importantly, students and young people, some of who are care experienced. You're all very welcome indeed. So Lord Colbrandon's legacy, our unique children's hearing system, touches all of the professions and services that interact with Scotland's young people. For this reason, this lecture series considers the vast range of issues that can impact on a child's upbringing and explores how, together, we can make Scotland the best place to grow up in. And this lecture is an important part too of the university's annual events calendar. Our university, Strathclyde, was founded by Professor John Anderson in 1796 during the Enlightenment period to be a place of useful learning. And I truly believe that our founder would recognise the importance of this event. The instruction in his will asked that this institution also be a place that was open to everyone, regardless of gender, status, or income, and values that you will recognise as being in keeping with the ethos of the Colbrandon Report. And we continue to be committed to useful learning. Strathclyde undertakes high-quality research and knowledge exchange across key research areas, including children, young people and families, health and well-being, citizenship and communities, and social and criminal justice. As many attending tonight's lecture will know, the Children and Young People's Centre for Justice, or CYCJ, has been based at Strathclyde School of Social Work and Social Policy since 2013. Since its inception, CYCJ has been passionate about ensuring that Scotland's approach to children and young people in conflict with the law is rights respecting, contributing to better outcomes for our children, young people and communities. And CYCJ is now led by Fiona Dyer, who is also attending this evening, and it produces robust, internationally groundbreaking work, bringing together children and young people's contributions through participation and engagement, research evidence, practice wisdom, and system know-how to operate as a leader for child and youth justice thinking in Scotland and beyond. CYCJ works closely with other organisations and individuals to ensure that children's rights are upheld and respected throughout the justice process, and that children are deprived of their liberty only when this cannot be avoided for the shortest possible time. Participation and engagement is, of course, a key theme of CYCJ's work, and the Centre works closely with children and young people who have experience of the care and justice systems so as to co-produce legislation and shape change. So it's my pleasure to introduce now Dr. Claire Lightowler. Claire was the director of the Children and Young People's Centre for Justice for 7 years, from 2013 to 2021. And during this time, she published a major report entitled Rights Respecting: Scotland's Approach to Children in Conflict with the Law. And the report explored whether Scotland was complying with the United Nations Convention on the Rights of the Child and what it would look like if children's rights formed the basis of Scotland's approach to children who are in conflict with the law. Through this work, Claire became increasingly aware of the need for children and young people accused of offending to benefit from specialist legal representation, which acknowledges their rights and legal status as children or young people, and is informed by knowledge about child development and trauma. To help her make a contribution to this work, Claire has recently started a law degree at the University of Edinburgh and is planning now to go on to practice law. The experiences of children in conflict with the law demonstrates that we need urgent action of a scale not seen since the Kilbrandon Report in 1964. Children in conflict with the law are exposed to significant trauma, adversity, stigma, and injustice. And these issues are often exacerbated by contact with the very systems and services intended to support them. For children in conflict with the law, responses to the COVID-19 pandemic have compounded pre-existing issues, whilst also hiding some children from view. One group particularly affected are the children locked up in Scotland's young offenders institutions, 80% of who are awaiting trial, having either not been found guilty or have not been sentenced to custody. So in the 19th Kilbrandon lecture, Claire will demonstrate the transformative change that could be achieved if Scotland viewed children in conflict with the law as rights holders and if we devoted greater attention to upholding their rights. Ladies and gentlemen, it's a great pleasure now to invite Dr. Lightowler to deliver the 19th Kilbrandon lecture. Thank you very much.
Thank you, and good evening, everyone. I'm sorry to be doing this in my room, but I am imagining you all there, and it's an absolute honour, wherever I am, to be delivering the 19th Kilbrandon lecture. Following on from, as Jim McDonald just said, some inspirational lecturers that have gone before me, as well as, of course, what we all do, build on the incredible work of Lord Kilbrandon and the Kilbrandon Committee. So I'm absolutely delighted to be here, well, not here, in this room, to be delivering the lecture. And I feel a great sense of responsibility to have this opportunity. And I think it is an opportunity to talk about children involved in offending. Because as I'm sure you know, these children tend to be misunderstood. They can be hidden from view. We often fail to hear their voices, and discussion about them is often highly emotive and simplistic. So I'm going to attempt to share what we know about children involved in offending in Scotland, bring into view more clearly these children and to amplify their voices and experiences. I think it's important that you're here, wherever that is, because these children desperately need change from us all. Last week, I had an amazing discussion with people, a member of the steering group, Youth Just Us, for the Youth Justice Voice project. So that's a project that seeks to amplify the voices of young people with care and justice experience. And I asked them what they wanted me to focus on and what it was really important for you to hear about. Their views have determined the focus of the lecture tonight and many of the points within it. You'll hear more about them later, and I'll reference them as we go. These issues are complex and emotive, as Jen's already indicated, and they're close, I know, to many of you listening tonight. So it can be difficult to face some of this, particularly as we're in our rooms listening. Please do step back if it gets too much. The names of organisations will be shared in the chat. And there's also CYCJ there that's been mentioned, who offer training and resources and things. You might find some of that information useful if there's things here that you're interested in. But more importantly, I think and hope, if you want to take action following the lecture, Fiona Dyer, the director, I've checked with her and she will be delighted to hear from you after tonight. So please do that if that would be useful and you want to do that. And please also reach out to me personally if you'd appreciate a conversation with me. My details will be shared in the chat. So please do, I'd be delighted to hear from you. So let's start then by reflecting on the work of the Kilbrandon Committee and how this has set the foundations for where we go next. So there's a Kilbrandon report on the slides. For me, what was and continues to be groundbreaking about the work of Kilbrandon is the underpinning ethos and the principles of the children's hearing system it recommended, and that obviously was then created as a result. Kilbrandon recognised that offending behaviours by children were to be seen as an indicator of concern for the child. Kilbrandon advocated a focus on needs rather than deeds, arguing that children in need of protection from others and children involved in offending should be treated in the same ways in the same system, because both groups were in trouble. the normal upbringing processes having, for whatever reason, fallen short. So Kilbrandon argued it's not helpful to separate out or treat any differently children who come to our attention with a label as offender from those labelled as victim, because the needs are the same. And of course, children who offend are almost always victims too. I think that principle is so fundamental to the children's hearing system, which seeks to support the child and respond to the needs based on what those needs are, regardless of the deeds and the reason and the route that a child comes to the attention. So the principles Kilbrandon articulated in 1964 continue to inform and guide what we do in Scotland and the decision-making by practitioners and policymakers. I don't think there can be many examples of a committee report like that, like Kilbrandon, that are still referenced in day-to-day policy and practice 60 years later. And you hear that, and I know you will know that, those who work in the sector, in your day-to-day work, we talk about the Kilbrandon ethos and what that means today for this child in these circumstances. And that's critical because the foundations Kilbrandon has laid means there's a common approach and understanding and set of principles shared amongst professionals and volunteers most of the time across Scotland, on which we can build. Kilbrandon came before concepts of children's rights and notions of participation were understood and established. And I think you can see that still today, but was still ahead of its time in creating an approach that saw offending as an indicator of need and in emphasising that the focus should be on the best interests of the child. But however, given the strength of this legacy and the vision of Kilbrandon, how come then we so often fail children who offend in Scotland? And we do. I'm going to argue that Scotland could do better, and that it's within our reach to do so. We've got strong foundations that we can build on, but we need to pay attention to the foundations. We need to reflect on what we're trying to achieve, on what we're doing and why, and we need a scale of change that we've not seen since Kilbrandon. We can't just rely on the legacy of Kilbrandon. There's a need for strong and brave advocates to speak up and think about these children, to make the case for why they need support and resources devoted to them if we're going to improve their lives and the lives of us all. So I hope to convince you to become such an advocate if you're not one already, to speak more loudly and clearly if you are, and to give you all greater insight and understanding. So that's the destination I hope we get to. And here's the evidence that I think gets us there. So who are the children who offend? I've focused this lecture on children, meaning those up to 18 years old, because the specific issues associated with the legal and social status of being a child. Those, again, who work in the sector will know this, but there's considerable complexity. I can't think of a stronger way of expressing it, but it's so complex about the circumstances in which 16 and 17-year-olds are considered children in Scotland, when they are and when they're not. I don't have time to go into all of that, and I apologise for that, but I will put some information in the written version of the lecture, and there is more information on CYCJ about that. And whilst my focus is on children, meaning under 18-year-olds, there's also a need to consider the specific needs and circumstances of young people, because they have very specific needs too, and are at a certain developmental stage that needs attention. It's not to deny that need too, but I'm focusing on children. There are some really encouraging developments in terms of young people and the recognition across Scotland of the need for a separate approach. This week, we've seen sentencing guidelines for young people be published and start to be implemented, which recognise the need for a different approach for all young people up to the age of 25. So really welcome things. I hope one day there'll be a Kilbrandon lecture about young people. But children, I'm going to talk about children. And if we think about children who offend, who are we talking about? Well, we're talking about children. Nearly all children commit a low-level offence at some point in their childhood. Based on self-reported data, the Edinburgh Study of Youth Transitions and Crime found that over 90% of children offended at some point in their childhood. Over half of children, the Edinburgh study is a longitudinal study, so they go and ask children and young people over their lifetime what's going on for them at different points. And when they asked children at age 12, over half of the children reported causing physical harm to another, usually a sibling. Around a quarter reported engaging in graffiti, shoplifting and fare dodging, and a smaller proportion reported being involved in more serious offending, theft at school, carrying weapons and so on. But whether we like it or not then, offending is a majority experience for children as they test boundaries, develop and grow. I think that's really important because there are consequences of othering and labelling a child as an offender when nearly all children are, and nearly all of us as adults did. Low-level offending may result in intervention by parents, by teachers, by peers, and so on. But the offending most children are involved in doesn't normally need to lead to a formal justice response. So when reference is made to children who offend in policy and practice, guidance and in the press and so on, what we actually usually mean is children who come into contact with agencies and organisations because of their offending or because they're accused of offending. And given that nearly all children offend, I use the term children in conflict with the law, which I think more clearly identifies we're talking about children who structurally have a conflictual relationship with the law, be that as accused, as charged or sentenced and so on. And children can of course be in conflict with the law, but be innocent of any offence. That's not to imply that there aren't really good practitioners working in collegiate ways. It's the system contact that is conflictual. And I realise the language it doesn't roll off the tongue. It's not easy to say, but I think it's important because it's more accurate. When talking with children and young people, I've sometimes used the term children in trouble with the police, which can be a bit more understandable and relatable sometimes for some people. But it's not just children's contact with the police that we're interested in, so it's not quite as accurate. But the police are interesting though, and let's have a look at the contact with the police first, because often that is the first point of contact for children in conflict with the law. So since the creation of Police Scotland, we no longer have data about the number of children charged with committing an offence in Scotland. That's a story in itself, but not for tonight. So this is a bit old now, but in 2012 to 13, 5% of children in Scotland were charged by the police. And that's about 24,000 children at that time. And the 5% of children who are charged are not always committing more serious offences or engaged in a more significant pattern of offending than the other children also offending, that 90%. The Edinburgh study again found that only 32% of those who self-reported as serious offenders when they were age 17 were ever known to social work or the children's hearing system. So most of those who consider that they were seriously offending don't come to contact with the system. Instead, certain children are more likely to come into conflict with the law. There's so much evidence about this and so many different groups of children for whom this affects in different ways. This is just a bit of a snapshot of some of the ways that this happens. So children who are economically deprived are 2.7 times more likely to face adversarial police contact than more affluent children who commit the same frequency and severity of offences. So that includes being charged by the police. And that's not just about the police policing certain areas, it's on an individual level. So there's something that happens in the interaction between the police and a child that is different for children that are more deprived than more affluent children. 1 in 9 young men from the most deprived communities spent time in prison by the time they were aged 23 years old. 81% of children under the age of 12 that were reported to the Children's Hearing System due to a pattern of offending behaviour had parents who were deemed to pose a risk to them. And the risk could be different. It means different things, but things like domestic violence, substance misuse, mental health issues, criminal behaviours, abuse or neglect. And the behaviours of care experienced children are more likely to be reported to the police and attract a criminalising response, even when those behaviours are trauma related, involve minor offending, and the specific issues in particular for children in residential childcare, when they're criminalised for vandalism or low-level behaviours such as trashing rooms or throwing things at people that in other settings wouldn't lead to a formal justice response. And there's lots I haven't talked about. Just quickly to say, there's children from Roma communities, children from certain minority ethnic communities, children that have certain disabilities, children that have speech, language and communication needs. There's so much evidence about this, and I mean, no disrespect to any group of children that I've not had time to mention. But in short, what you can read from this is children in conflict with the law are the most vulnerable children. There's a lot going on here about why and what happens, but one of the things that seems to happen is that people, professionals and other people see a child in need and they're understandably concerned and feel the need to do something and respond, often primarily to the vulnerabilities or due to concerns about managing risk. But when offending is part of the picture, our responses to that draw children further into conflict with the law. And for example, then, just to describe and illustrate how this works, whilst half of the children at age 12 had caused physical harm to another person, and this is usually a sibling, in most family settings, this is likely to be dealt with within the family. There might be punishment, there might be consequences, but rarely would that lead to a criminal record. And you remember the Edinburgh study, that's what it demonstrated for most children. But for children in care, such incidents are more likely to be viewed through a lens of assault with the police called. So the same actions have different long-term consequences, with the more vulnerable children being more likely to be drawn into a justice process. If offending by children was truly understood and entirely responded to as an indicator of need, and if contact with justice-focused organisations and professionals helped them address those needs, this wouldn't be a particular issue. I wouldn't need to be here speaking. But the flaw in this is, once a child becomes known as engaging in offending behaviour, then their behaviour is seen through this lens, and it becomes increasingly difficult for them to escape this label, which leads to all kinds of negative consequences for them. Parents might want their child to avoid the labelled child. Teachers might be more likely to see school exclusion as an appropriate response to behaviours. The child might be excluded from activities and things they love, either as a punishment or an attempt to manage risk. We might all start to see a child's behaviour in a certain frame, perhaps as risky, as frightening, as threatening, meaning that we miss the child as in distress or that they're being exploited, with issues of child criminal exploitation, when children are exploited and manipulated by others to commit criminal acts, a well-documented and often missed underlying issue of children's offending. And we might stop seeing the whole child. So this focus on offending behaviours can encourage us to miss that a child is also fun. They're interested in art and drama and football. They've got strengths, they're a good friend, they're loyal, they've got skills, they've got good qualities. We can miss the child, and we can all do this in our personal and professional lives, often for understandable reasons and concerns. But this process of labelling and excluding takes away the very things that can help a child develop good and positive interests and relationships with others. The more we exclude a child who's beginning to offend and become known for offending, the more we can push them into further offending, as the only way then of finding meaning, of finding relationships, things to do. And if they're going to be seen as an offender anyway, sometimes it can be easier to just go with that. It's exhausting fighting it. As a young person said to me, what's the point? And here's a quote from a child in prison explaining this process a little bit. After I got excluded from school, I started robbing houses, stealing cars, drinking every day, smashing stuff up. One of the most profound findings of the Edinburgh study is that the key determinant of whether a child will continue offending or not as they develop and grow is if they've had contact with the children's hearing system. Children who don't come to the attention of the children's hearing system are more likely to stop offending compared to children committing the same offences at the same frequency from similar backgrounds. There's also indications to suggest that the more informal channels too, such as early and effective intervention, which is a multi-agency response to low-level offending, it has the same effect. In this case, acting to escalate children to the children's hearing system that may otherwise have stepped away from offending. That's a pretty horrific finding, because it indicates that despite the best of intentions, despite all the goodwill and the good work, where we intervene in response to offending, it often makes things worse, at least in response to their offending behaviour. So it suggests we need to be extremely cautious about unintended consequences when we respond to children. And we need to be cautious of labelling, stigma, up-tariffing and escalating system contact. We've got a major problem then. Scotland's approach to children in conflict with the law makes things worse. And the more we focus on preventing offending by individual children, the more we're likely to unhelpfully label, stigmatise and draw children ever further into conflict with the law. But of course, that ethos is right and that drive is right. We absolutely should be and want to be doing all we can to prevent children from coming into conflict with the law in the first place. So how do we do that without the negative consequences I've described? So what I came to realise, and this somewhat describes my journey personally as well, what I came to realise is we need a new way of thinking. We need new foundations to underpin our approach. In the Rights Respecting report, it's a long report, but there's a summary and there's a child-friendly version. So I hope you'll find some of that useful if you're interested in some of the content tonight. But in that report, I explore whether children's rights offer us a way to rethink and reframe and to strengthen the foundations of what we're doing. I concluded, and it's perhaps no surprise at this point, that Scotland would benefit from making the focus of our approach with children in conflict with the law about upholding rights, wherever they are, whichever organisation or agency they're interacting or supported by. Because the response to children in conflict with the law since Kilbrandon can be seen a little bit and has been described as a balancing act between welfare and control. Sometimes with the balance tipping one direction and sometimes the other. Some organisations focusing more on the other. Some interactions are more on one and the other. But both approaches contribute to the problems I've described. Both involve labelling and stigma. So instead, what if we cut through that? What if we focus on upholding rights and ensuring children have rights respecting pathways, rights respecting journeys, experiences, interactions, relationships? Well, something happens, I think, when we focus on children as rights holders and on the role of others to defend their rights. Rather than thinking about children as troubled or challenged or vulnerable or challenging, it can be a powerful relabeling, a new non-offending identity, which has the potential to help a child and those around them think differently about who they are and what they need. They are a rights holder. and those around them have responsibilities to defend their rights. Of course, that doesn't change anything in and of itself. A child might still be vulnerable, there might still be challenging, all that is true, but a focus on rights can help to put the onus on the system, the agencies, the organisations, the politicians, the professionals and so on to ensure that rights are being upheld, rather than focus on the deficits of a child or a family or a community, which these vulnerable or challenging type labels can do, however well-meaning they are. I was really struck by this comment from Paul Gilroy from Crossreach, a seminar series. I had the pleasure of attending about stigma. And he was talking here about the process of third sector organisations applying for funding, but I think it applies beyond that. And it's a really honest reflection. We stigmatise people to get money, to deliver services, to destigmatise them. And I think that's so often true. And to some extent, you may accuse me of just doing it, as I've talked about vulnerabilities and needs and concerns, but the importance of not stigmatising. But making upholding rights our purpose means we don't have to label children. We don't have to label them as vulnerable or at risk of future offending in order to provide care and services and support, in order to intervene in their lives. Instead, the state is required to ensure that all children have access to education, healthcare, good quality standard of living and so on, because they're entitled to it. And the state needs to pay particular attention to those least likely to have their rights upheld. Of course, the evidence is clear. These things, education, healthcare, standard of living, the rights set out in the United Nations Convention on the Rights of the Child, UNCRC, these all contribute to preventing future offending, but at an individual level, we don't need to stigmatise children, families or communities. Instead, we focus on ensuring rights are upheld, but we prevent offending by respecting the rights of children. Reframing our purpose as upholding rights is obviously, I hope you don't think I'm trying to claim it's a panacea, it's not. And if rights are not respected, then simply saying someone has rights, simply saying they're a rights holder, it's not just meaningless, it's painful and potentially traumatizing. If you say I have rights and I don't have rights, then that causes harm. And I'm reminded here of a really brilliant rights respecting primary school I had the pleasure of visiting in Wales. Sorry for the poor quality photo, but I hope you get the sense of it. The rights were everywhere, written everywhere. The children were talking about their rights, having disputes about which rights were more important in which circumstances. It was truly incredible. But the school reported that when they're empowered, rights-aware children went to secondary school, the children struggled because they met a culture that didn't acknowledge or respect their rights. So it's not enough to reframe what we do about rights. We need to make the rights real. So in the Rights Respecting report, I explored how Scotland was doing at respecting rights of children in conflict with the law, and specifically whether we were compliant with UNCRC. I know some of you will know this well, but UNCRC is an international agreement. The UK government has already committed to it, but the Scottish government is also planning to incorporate it into the Scots law, which strengthens the opportunity for legal challenge when and if rights are not upheld. So I identified 11 areas where improvements were needed if we are to respect the rights of children and comply with UNCRC. And the report details how we could make progress on each of these. There's quite a bit of detail about things we could do, practical things at all different levels. And none of them are any more important than any of the others. But I'm going to focus on the two issues tonight that were identified by Youth Just Us as the most important for you to hear about tonight, and that's children in prison and children's participation. So children in prison, there's many areas where our approach is going badly wrong, but one of the clearest is our children in young offenders institutions or a prison. In Scotland, it's now always the case that those under 18 that are in custody will be placed in Pullman Young Offenders Institution, but they can and still are at times placed in other prisons. So I'm just going to talk about children in prison as shorthand for both of those things. Children aged 16 and 17 can be placed in prison, with younger children who are considered to require to be deprived of their liberty, either for their own safety or the safety of others, placed in secure care. And the first thing to say is we've seen a significant and welcome reduction in the number of children in prison. So in 2010 to 11, there were 658 children who left prison that year. And in 2019-20, there were 136 children who left prison. So a reduction of 79%. However, there's still about 100 children or so a year that leave prison, and there's serious concerns about the children who go to prison and their experiences. Their rights are not respected throughout, and here are some of their rights. So taking one day, take the 7th of January 2022, there were 15 children in prison on that day. Of these children, 11 were untried, 1 was awaiting sentence, and 3 were sentenced. So that means that 11 children were in prison who had not been found guilty of any offence. 1 child had been found guilty, but they had not been given a sentence. So when they are, that might involve custody, it might not. The status of being in prison before being sentenced is known as being on remand. And so 80% of the children in prison were on remand on the 7th of January 2022, 80%. That's not an unusual day. Since January 2021, between 76% and 94% of children in prison were on remand. Just as a comparison, it's about 40% for adults in Scotland. So why is that? Why is such a high proportion of children in prison on remand? Research with sheriffs and procurator fiscals about their decision-making to use remand rather than release a child on bail shows that the decision is not always about the risk a child poses to others. Sometimes the decision is based on the child's needs and the lack of services and supports in the community, specifically a response to a child being homeless or a lack of supervised bail being available in their local authority. So the pattern that we saw earlier is the same here. Those who are most vulnerable are more likely to go to prison, suggesting a major breach of Article 37B of the UNCRC that deprivation of liberty should be used as a measure of last resort. It should only be used when it's the only possible way of keeping others safe. And the experience of being in prison is horrific, but being on remand is additionally so, because you don't know how long you're going to be there, and potentially you don't know whether you're going to be found guilty. Here's a quote from a child in prison on remand. "I see when you're waiting to get sentenced, it's torture, because you don't know what's going to happen, and you just want sentence to get it over and done with. But when you get sentenced, it's oh fuck, then you get used to it. When you're on remand, because you're not guilty of any offence, no specific offence-focused work can be undertaken, and there's a range of prison activities and supports you're not able to access. It's often referred to as wasted time." Here's another quote from a child on remand. "When I was on remand, I was locked up 23 hours a day. It's not good. Then when I got convicted, I'm out all the time. I'm never in my room, only at night. Remand's boring. You only get the gym and rec, and that's it. Or a visit. There's no work parties, there's no nothing. Time on remand is and can feel long. For a child, that can have psychological consequences as well as really practical ones." Here's a quote from a sheriff. They can be in custody for 110, 140 days. So that person's liberty is at stake for quite a period of time. And of course, a remand for a young person might be particularly, because a week's a long time in politics, but 3 months is a desperately long time if you're a young person. And from a social worker, remand is a disaster. All the stuff we know about remand. First, it's a 7-day lie down, which is enough to scupper a lot of the stuff, also the seeds. Anything more than 7 days, you start to lose tenancies, benefits claims are screwed up, education, the course you fought to get them on is gone because of heavy demand. It has knock-on effects, they're taken out of society, you know. The bail and remand research that these quotes were taken from was conducted before the pandemic, but obviously the significant consequences of this that's compounded an already really serious issue. Her Majesty's Inspectorate of Prisons for Scotland worked with others to conduct a survey in 2021 of the Children in Pullman Young Offence Institution, and it found some pretty distressing statistics about children's experience in prison. So 67% of the children had less than 2 hours out of their cell, suggesting, I think, cruel, inhumane and degrading treatment, if not meeting the international definition of torture. 83% of children reported not having enough to do, just under half felt stressed or anxious all of the time. These experiences will be difficult to cope with for anyone, but for these children, they entered prison with already significant challenges. For instance, 1 in 4 had previously attempted suicide. 85% had been excluded from school, 1 at age 5, and 42% were care experienced. There's also often hidden stories of children that have ended up in prison because they've been trafficked into the country or because they've been exploited by criminal gangs. There's a powerful article by Karen Goodwin from The Ferret about children from Vietnam who were trafficked in this way and ended up in prison. But these stories are hard to find. And sometimes, because 16 and 17-year-olds can look like tough, strong, aggressive, scary men, we miss what's happened to them and what they're going through. COVID's compounded the issues because we have considerable court delays, meaning children are likely to be on remand for longer periods. They've been through various lockdowns when children in prison were unlikely to have face-to-face contact with family, friends, legal representatives. Access to services, to education and activities were reduced. It was difficult at times for third sector organisations and supports to get into prison. In such circumstances, young people tell us those in prison are increasingly resorting to using substances to self-medicate, to pass the time, and to psychologically at least escape, with the use of spice absolutely rife amongst children and young people, even those who've never used it before prison. And there are concerns around how children already hidden from view have been further isolated from us all, and what we don't know is happening and what they're going through. Most of the children then we lock up in prison have not been found guilty. Most are not accused of committing the most serious offences. And on average, the children in prison in 2019-20 were there for 2 months, 59.9 days. I find it difficult, actually, to talk about this and comprehend it, because what we're doing then is taking traumatised children, we're exposing them to extreme additional trauma, we're giving them new issues to deal with, and then we're returning them to the community with no or little additional support. And there are, of course, children who don't return to the community. Sorry. It is emotional. It is emotional. Since 2009, 2 children and 25 young people aged 18 to 25 have died in prison, 56% of whom were on remand. If I could, I would read out the names, but please read the names. Deprivation of liberty is not always used as a measure of last resort. It's not always used as the only option to keep others safe, when we've considered every other thing that we could possibly do to manage absolutely what are sometimes risks that need to be managed. There are very few children for whom deprivation of liberty is it's the only way we can keep other people safe. And if we respected children's rights throughout, there'd be fewer still. But wherever this is the option, Scotland has secure care centres which are more clearly child-centred, educational focused spaces capable of delivering a trauma-informed approach. Here's some views of children in prison. Secure is more likely to help me if I was there for a long period of time. I've been in and out of prison. This place doesn't help me. I'd be better in secure. A wee boy tried to kill himself the other day. He sent him here for 7 days when he should be insecure. He's just a wee boy, not cut out for prison. What really gets me about that quote is that it's a child reflecting on how another child is not able to cope. Of course, children do not always experience secure care in Scotland in a positive way either. And there are gaps in what we know, but what we do know indicates that their experience and outcomes are significantly better than those who go to prison instead. But secure care is not always considered an option, and there's been issues before about the availability of secure places in Scotland, or a perception that there's not places available. During the pandemic, when there was grave concern for the health and well-being of those in prison, some people were able to be released early. Over 340 adults were released early, but just one child was. Largely because such a high proportion of the children in prison are on remand, and those that are on remand were not able to be released early under this scheme. I think it's telling that, as far as I can tell, there was no specific consideration paid to the children in prison and what could be possibly done for those on remand in terms of transferring them to supported community settings or to secure care, which during the pandemic was no doubt better able to support continued access to leisure, education, contact with the family and so on. We're talking about a small group of children now. So it was and absolutely still is doable to look at every individual child and consider on a case-by-case basis whether children as a minimum could be transferred to secure care. There's nothing in the public record to suggest that this was given serious consideration, that these children were really thought about when developing a response to the pandemic. One example, I think, of why strong and brave advocates are needed. The Scottish Government has committed to deliver the recommendations of the Independent Care Review that no child should be in a young offenders institution or prison by 2024. But given the impacts of COVID, the additional mental health issues, the court delays, the disruptions in relationships, there's a real urgency to address this immediately. So this was one of two issues identified by Youth Just Us as being the most important to them. And the final issue I'll address is that of participation. So Article 12 of UNCRC sets out that children should be given the right to express their views in matters affecting them, that their views should be given due weight in accordance with their age and maturity, and in particular, they should have the opportunity to be heard in any judicial or administrative proceedings affecting them. The conversation I had with Youth Just Us members highlighted the importance, how important relationships were to them. They wanted people. They wanted people to spend time with them, to build a relationship. They didn't separate time and relationships. They saw these things as interchangeable, and they referenced a huge range of people that were important to them: their peers, mentors, panel members, social workers, safeguarders, Action for Children workers, many of you who will be listening tonight. And what they want from you is to give them time, to listen to them, to challenge when their best interests are not being served, and to fight their corner. Their comments echoed research done with children and young people in the justice system during the pandemic and the early stages of the pandemic. Here's a quote from a child with previous experience of the youth justice system. "Spend time with me, encourage me to do things, even though I mostly say no. But I really like it when a few staff come in and sit with me, make me laugh, and even discuss my past." There's no doubt that many children and young people, particularly those in conflict with the law, have been even more isolated and had relationships disrupted during the pandemic. There's obviously been some amazing and creative work to maintain connections. The Youth Justice Voices project itself being highly valued as important to the members I spoke with because it moved online. It ensured members had what they need to not just communicate, but really actively engage. They developed creative methods and activities. They responded in an individual way to each person involved in the group already, and they continued to reach out to children and young people that they didn't know. The group explained to me how they want to be involved in decisions which affect them and which they have expertise on. They mentioned how even now, Scottish Government consultations like bail and remand, and that's a consultation that's out right now, it involves a process that's designed for professionals with no meaningful opportunities provided for children and young people to have their say, despite how important that issue of bail and remand is for them, which I outlined earlier. They also shared how they want to ensure that children currently in care and justice settings can have their voices heard too. For instance, to be asked what activities they want to do, to be given opportunities to do classes in drama and art and music, whatever is important to them, and not to have their opportunities limited when they're the only one who wants to do these things. They cited the example of being in residential care and having to do what the majority wanted, which was often football. And the reasons that they thought that was about staff not having the time to take everyone to the activity that was important to them, or there not being money to do those things. What's also important is that children can participate in justice processes, particularly in children's hearings and in court. It's estimated that over 60% of children in conflict with the law have a speech, language, or communication need. You can perhaps imagine how children who offer monosyllabic answers avoid eye contact, struggle to find the right words, and potentially are potentially going to be perceived if their needs aren't understood, and often their needs are not understood. But even without a specific need, children at a children's hearing system or a court, they're almost always likely to be experiencing stress, which makes it challenging for them to process what's happening, especially when you consider the language used in these settings. And whilst a couple of areas in Scotland have youth courts, most children who go to court will experience a standard adult court setting with little, if any, accommodation made to recognise that they're a child. There's some amazing examples of practitioners taking off wigs and sitting with children and looking to engage, but the environment, the context, the structure, it's an adult court. In 2019 to 20, 1,208 children were prosecuted in the court. I think that's a fact often hidden by a focus in Scotland on the children's hearing system. In that same year, just under 3,000 children referred to the children's hearing system on offence grounds. So it's a significant proportion of our children in the formal justice system that go through the court. And very often these children are 16 and 17-year-olds, which goes back to the issue I alluded to about when we treat children as children. But not surprisingly, children report that they don't understand what happens in court. Here's a quote from a child in prison. "I was in court the day after my 16th birthday and didn't know what was happening. I just didn't have a clue." We're not even ensuring that children understand the justice processes that they're subject to. But we need to do more than that. They need to have opportunities to speak, to have their voice heard, to be able to explain their point of view. We're a million miles away from that in the courts and in many of our interactions with children in conflict with the law. So I've covered a lot of ground here. I hope it's made you think and better understand children in conflict with the law. But most importantly, I hope you do something with what you've heard to really ensure that these children have their rights respected. And wherever possible, you include them in your relationships, your schools, your communities. Kilbrandon's given us such strong foundations, an approach built on best interests of the child, a focus on responding to offending as an indicator of need, a system which doesn't separate these children out as other. We've lived with these principles for 60 years, so there's a depth of understanding about what this means and what happens. But we need to tend to these foundations and we need to extend them to ensure children's rights, participation and inclusion are truly embedded throughout every child's life and their journey. This needs more than just thinking and understanding. As a young person said to me last week, stop talking about it and do something about it. This is just a lecture. These are just words, but you're a listener and you can do something. Because these children really need you to be brave for their rights. Thank you.
Thank you very much, Claire. You've spoken with such authority and compassion. You've really brought children in conflict with the law to the very center of our hearts and our minds tonight. I think your compassion and your deepest concern for the injustice that you've outlined will resonate with so many others here tonight. Our audience will have a wide-ranging experience and will feel compelled and validated, I think, as that same sense of compassion and outrage and injustice will be at the heart of what drives so many people who are here tonight. You've asked us to look really differently at the wider systems and its risk of creating further harms, and that despite the substantial changes and the progress that have been made, that these changes haven't been enough. Thank you, Claire. This is an opportunity now for us to hear from two colleagues. Let me introduce them both and tell you who they are, and then we'll hear from Claire again with her reflections. Professor Ursula Kilkelly is a professor of law at the University College Cork. For those of you who may not know Ursula, she is a phenomenal thought leader in the area of international children's rights and youth justice and detention, with a very well-established profile through many monographs, edited collections, co-editor of youth justice, and among many other roles, Ursula is the founder of the Child Law Clinic, providing research services to those litigating children's rights. And Ruth Carricker is the youth justice participation lead at the Youth Justice Voices, which is in partnership with STAF, the Scottish Through Care and Aftercare Forum, and CYCJ. And this project aims to influence change by enabling young people to creatively amplify the issues and the recommendations for change with policymakers, managers, corporate parents, and the Scottish Government. And so we look forward to hearing from each of them a response to this very compelling presentation from Claire. Thanks, Ursula.
Thanks, Jennifer, and good evening, everybody. And thank you, Claire, for such a powerful address this evening. I think it's really fitting that this lecture tonight has focused on an area where I think we've seen less than the usual ambition from Scotland. And what I'd like to do with the few minutes I have, hopefully to build on what you've told us this evening, is to reflect back into the international human rights and children's rights framework, all the lessons and the messages, I suppose, that come both from international children's rights standards with regard to rights respecting youth justice, and also the increasing evidence about how important and why it's so important to take a rights approach to youth justice and detention. I only have a few minutes, but I want to give you a flavour of the work that I've been doing in this field that I think very much complements the the philosophy that you've set out, Claire. And the starting point of this is that the children's rights approach is fundamentally about rights for all children in all circumstances. It's a non-judgmental and universal approach to all children under 18 years, regardless of their needs, their complexity, regardless of their behavior. It's a universal approach that puts children first. It's a fundamentally child-centered approach, and it speaks to the specific circumstances and characteristics and needs of children as children. So these are fundamental building blocks, really, on which the rights-based approach can be built. Work that I have done most recently in relation to detention has helped to craft my thinking around 5 areas where I want to briefly speak to you about where rights can be brought to bear on youth justice. I think while I developed it in relation to detention, it has resonance in the wider youth justice context. And it draws on some of the existing children's rights categories of rights. So the first one is provision. This idea, whether through early intervention, whether through diversion, that children have a right to have their basic needs met, whether that's care, health, education, development, play, leisure. These are basic fundamental rights that all children are entitled to. So their basic needs are entitled to be met under provision rights. The second is in relation to protection, where of course children have a right to be protected from harm, but they also have a right to be protected from other risks to their own protection of their own welfare, to recovery when they have suffered harm, whether that's health harm or harm from others. And really looking to ensure that we divert children to spaces that are safe for them to be able to fulfill their rights. The third, and you've spoken very eloquently about this, is participation. Whether we're talking about due process rights in court, whether we're talking about children with the right to a say in decisions made about them individually, or whether we're talking about involving them, giving them a voice, hearing what they have to say and acting on it in policy matters, in the development of new approaches and review of existing ways of treatment. Participation is absolutely key. The fourth, and probably an additional one, and some new for some, is the concept of partnership. So we need to not just work with young people and support and develop them as we work through youth justice. We also need to partner with families. We need to partner with communities. We need to network. We need to coordinate and collaborate right across the children's sector, the criminal justice sector, health, education, all these areas working together, I think makes partnership a really fundamental right of the child in the context of youth justice. And the final P is in relation to preparation. And I use it mostly with regard to the importance of preparing children for leaving custody, but also for leaving the justice system. Rights are fundamentally important now for children. But it is also important that we look ahead, that we prepare and support them to develop in a safe way, in a way that can allow them to fulfill their potential. And so preparation really speaks to that goal. And then I suppose when we reflect on those 5 Ps, my work has identified a number of areas where we need to really settle our ambition at a national level. What we know, for instance, is that we need explicit commitments in law and policy to a rights-based approach. We need clear direction from government. We need that foundation to be set in law and policy direction, a whole system approach. We need resources, and frequently law and policy, the resources will follow the direction set by policy. But we also need people. And that's where I think this evening's lecture is so critically important. Over 200 people online listening to what you have to say, Claire. We need ambition, we need vision, and fundamentally we need leadership to put children's rights at the heart of youth justice.
Thank you. Thank you both to Claire and Ursula there for raising some really important points. And thanks to Claire for providing us with such an important lecture. You've really highlighted how we need to reframe not only how we support children in conflict with the law, but also how we perceive children and young people more widely. I hope your words spark action so that as a nation, we start to realise that all of our children are active rights holders. As Claire mentioned, she had the pleasure of meeting Youth Just Us, a steering group of phenomenal young people. Young people involved in this project have experience of both the care and justice systems in Scotland, and a real desire not only to be heard, but to have their views acted on. Young people aged 16 to 25 have been involved in the project since 2019, influencing change and steering what staff in CYCJ's National Participation Project, Youth Justice Voices, has become today. Before I go on to provide a more formal response to the lecture, which includes the views of Youth Just Us members, I wanted to highlight a few things which struck myself and the group. Upon meeting Claire, many of the young people shared that they had never heard of Kilbrandon. They also wondered why they had not been asked to contribute and influence a lecture like this before, which is ultimately talking about their experiences and what needs to change in Scotland. They believe that young people's voices should be at the heart of all future lectures, and they too should be able to lead responses and direct questions at everyone here today. So again, I want to thank Claire for not just taking the time to listen, but also ensuring that the views of young people were represented and influenced the content of the lecture we've heard today. It's clear that Claire sets out in her rights respecting approach that is based on years of learning, research and evidence. She builds upon the groundbreaking work of the Kilbrandon Committee, recognising that offending behaviour is an indicator of concern for the child, demonstrating the need for care and protection, and with the focus on needs, not deeds, there is the opportunity to respond from the same children's hearing system. But Claire goes further to acknowledge that we need to do better, recognising that children and young people are in fact in conflict with a system. The members of Youth Just Us pointed out that children are in conflict with many systems, particularly when they grow up in poverty. This is the first point that Youth Just Us wanted to highlight in the response. The impact that poverty has on so many children and families' basic human rights and needs in Scotland. It is their belief that it's often the root cause of children and families coming into contact with multiple systems in the first place, whether that's care, justice, welfare, or housing. This is why the emphasis on changing how we regard and respond to children and young people is vital. We need to see children and young people as rights holders, and like Claire has suggested, professionals, services, and ultimately the system's role should be to protect and uphold these rights, treating children as children, not labelling and escalating their contact with the justice system, or worse still, locking traumatised children in adult systems and prisons, which strip children of some of the most important relationships, experiences, and years of their lives. At Youth Just Us, we have had discussions around the issues Claire has highlighted. Young people continually tell us that they are in a legal system they do not understand. To quote, "It diminishes your sense of self-worth and identity. The language used, formal processes, jargon, legal terms, complex systems, let alone scary gowns, wigs, and settings like courts can feel alien and inhumane." To quote again, "It's almost easy to forget someone is a person, let alone a child." Claire has eloquently highlighted many of the concerns, but she's also pointed to community alternatives and more appropriate spaces and approaches which can manage risk and help people to overcome harm when required. Members of Youth Just Us have suggested that we need to make community alternatives more meaningful, so they enable children and young people to move on and strengthen skills and qualifications as opposed to just being there to purely punish. Their key ask, which you've heard from Claire and what I want to echo again, is that young people want adults and professionals to take the time to get to know them, to build positive relationships, to provide safe and creative spaces where they can express themselves and develop as a child, a young person, and as an adult. To me, this highlights the important role that universal youth work, CLD, and youth-led participation projects can impact on not just young people's lives, but whole communities. Like Claire has highlighted, along with the members of Youth Just Us, We know a lot of the answers already. Children and young people have told us time and time again what needs to change, which is evident when they complain of being asked the same questions in adult spaces with no feedback or payment for their expertise. Participation needs to be greater than this. Thank you once again to Claire for her emotive lecture. You've certainly inspired me. Hopefully, if we reframe our thinking, we will see children and young people as assets to our communities and rights holders who should shape the supports, services and policies which affect them. Or in simpler terms, as one of our young people said, we don't need people to be brave. We don't need superheroes. We just need people to respect our rights and uphold their responsibilities. Ask us, what can I do to help you? Thanks again to Claire for this opportunity. I have a few questions I would like to now just share on the behalf of Youth Just Us for you to consider, Claire. So the first one is, what can we learn from other countries internationally? This is in reference to examples of where you value their approach to rights and justice. Secondly, the next question is perhaps more rhetorical, but it's actually really impactful when we've listened to your lecture and what Ursula has had to say. Rights are on the walls across schools. Why are they not across all the walls of the justice system?
Thank you, both of you, for those fantastic contributions that have taken us to two very different places, the kind of international perspective and the children and young people's perspective. I think what's clear across all of it is that there's so much to draw on. So in terms of the questions, where can we learn? Well, sort of everywhere. Other countries, but also good practice in Scotland, good practice locally, good interactions. There's some amazing work from everywhere. I think, and Ursula will know more about particular pockets in particular countries, but my experience is there isn't one country that has it all solved, that has something, a model, an approach that you can just take and apply. And as I've tried to articulate, we have real strengths in Scotland that we can build on. So learn, yes, but don't try and replicate. Try and grow, try and learn and grow and interact in a culture, in an ethos that is Scottish, that is responsive to Scottish children in Scottish communities. And I think that's a bit different from traditional models of taking an idea and a concept and applying it. Often negative things come from that because cultures are different, attitudes are different, approaches are different. So whilst there is really good practice in individual countries, I think it's more reflecting, learning, growing, building and developing our practice with openness and awareness of learning elsewhere. That's kind of how I think about it. And I see that there's a question about that and about whether my kind of comments about Scotland's approach makes things worse and whether this is limited to Scotland. Well, absolutely not. I mean, I think just about, I can't think of an example of a country which doesn't involve, when it's responding to children's offending, that doesn't involve some element of stigma and labelling and the system contact kind of issues I've talked about. But that doesn't mean that Scotland doesn't have that issue to address. And I think sometimes we don't face up to that in Scotland. I've focused on Scotland because I am here, I am working here, I want to improve things here, but it's no reflection, it's no comparison with other jurisdictions. So hopefully that answers that question a little bit. And I think, sorry, what was your other question, Ruth? Remind me, there's two questions.
So it wasn't really a question, it was more young people are making the comment that if you see across schools, I suppose like you've seen in Wales, you've got rights all over the walls. Why is it any different for children and young people in the justice system? Why do we not know about their rights?
Yes, excellent point. I mean, I think that goes back to the kind of fundamental point I was trying to make. We don't think about these children as rights holders. That that way of thinking is quite new. It's quite new across lots of settings. I think, rights, really embedding what that means is quite new for many people, many practitioners on a day-to-day level. So it takes a bit of time to think through. I am conscious that, my work has been about children in conflict with the law, but I needed to take a year's sabbatical to really give myself time to think about what would a rights respecting approach look like. I'm totally aware that nobody else, I'm so lucky to be in that position. Hardly anyone else is going to have that opportunity, and certainly not busy practitioners that are doing the day-to-day job of interacting with children and families. They're not going to have that time and space and luxury to think in that way. So it's a privileged position to be in. So it's totally understandable that that's not filtered through, that people are grappling with what that means. But I think it does go to the root of, we need a reframing that recognises these children as rights holders, and all these settings, that the purpose is about upholding rights. And what that looks like, there's been, UNICEF has done quite a lot of work about rights respecting schools, but I've not heard the same phraseology about justice settings. And I don't know how comfortable I am with that phraseology in certain justice settings. Could you have a rights respecting prison for children? I don't know. You can have rights respecting practice, but there are some settings and some circumstances for which that doesn't necessarily sit easily and comfortably. So I think there's things to be really teased out there. But what's really important is that children know their rights, and that they understand their rights and understand and are empowered to use their rights. What was impressive about the school was they would say, but I have a right to play, and they would navigate, well, what's your right? And they were talking about how they needed to respect the teacher, and the teacher had rights too. So it was a really complicated and sophisticated understanding of what that meant in their circumstances. So yeah.
Claire, Ruth, and Ursula, thank you very much for those reflections that helped, I think, the lecture that you've given us, Claire, to sort of embed more deeply in, as we're sort of thinking this through together. It's a lot you've given us that's been so important for us to not lose sight of. So thank you for helping us. And now moving on. As the sponsor, the Scottish Government plays a key part in enabling this important Kilbrandon space. And so I'd like to invite Minister Claire Haughey, Minister for Children and Young People, to offer a vote of thanks. Thank you.
Thank you very much, and good evening, everyone. It's my absolute pleasure to thank Dr. Lightoller for delivering this year's Kilbrandon Lecture, and all of those who have helped to make it happen. Claire, in delivering your lecture tonight, you have demonstrated your deep knowledge, but I think almost more importantly, your passion and your drive when it comes to supporting children in conflict with the law. And I don't think there's anyone who could feel to be moved and motivated by the lecture that you've just given. You've illustrated the need for deeper reforms so that we create the legal system that children and young people in Scotland need and deserve. And it's important to reflect on the journey Scotland's care and justice sector has been on, thanks to the tireless work of volunteers, professionals and experts. We've seen the levels of harm and of offending by young people drop sharply. And we've established programmes such as the whole system approach, which have proven to be making such a difference. As we set out in our latest programme for government, we are committed to safeguarding young people within the youth justice system, and we support a presumption against under 18s in the criminal justice system, keeping them out of young offenders' institutions where possible and appropriate, whilst ensuring that victims receive the support that they need. Last June, we published a new vision for youth justice, and this work has been hugely influenced by both Claire's own rights respecting report that she spoke about tonight and by the promise. but critically, it has been informed by children and young people with experience of the care and justice system. Within government, we're working with partners to address many of the issues highlighted in tonight's lecture, including the number of under 18s in young offenders institutions, particularly those on remand. And in doing so, we need to give close attention to the children's hearing system to secure care access and to community alternative provisions in Scotland. Legislative reforms will be required along the much needed policy and practice change. To go share many of those ambitions. As we continue to make progress, our focus naturally shifts to those young people whose circumstances and behaviour are the most complex and challenging. And it's essential for their safety and well-being and for the safety of their communities that we get our approach right. Thank you, Claire, for the unique perspective you brought to this year's lecture. And we must approach these issues with care, and my colleagues and I will hold your vital insights and your challenges in our minds as we take reforms forward. You spoke about the need for strong and brave advocates to speak up, and undoubtedly this is a role for all of us. Turning now to those who have helped make tonight happen, and I would like to thank the Principal, Sir Jim MacDonald, for his introduction, and Professor Jennifer Davidson for chairing. And I also very much appreciated the contributions of Professor Ursula Kilkelly and Ruth Kerricher. And I'm very grateful to the young people who worked with Ruth to help her shape her response. And please, Ruth, do pass on my personal thanks to them for their input to tonight's proceedings. Thanks also to Fiona Dyer and the Children and Young People Centre for Justice for your crucial work with young people and professionals. And on behalf of the Scottish Government, I would like to convey my gratitude for the continuing support given to this lecture series by the University's School of Social Work and Social Policy. In particular, thanks to Raymond Taylor for organising tonight's lecture, Nadia Mitchell for the support from the university's events team, and Alan McLeave for ensuring that these things have run smoothly. And finally, my sincere appreciation goes to all of you who've joined us for tonight's lecture, particularly those directly involved in the hearing system as panel members, reporters, social workers, teachers, and in many other roles. You've made an enormous difference to the lives of thousands of children and families. And our unique and valued children's hearing system will continue to evolve and to thrive thanks to your dedication. I'm now going to hand back to Professor Jennifer Davidson, who will conclude tonight's proceedings. Thank you.
Thank you very much, Minister. It leaves me now to say two small details that you may be interested in. Claire's lecture will be available in the Scottish Journal of Residential Childcare. It will be published, and the video will also be available on the Kilbrandon website, which you can find on the Strathclyde Social Work and Social Policy website. Just Google Kilbrandon Strathclyde. I'm sure you can very easily find it, where you'll find a whole library of previous lectures, which is a fantastic resource. I'd like to echo the Minister's comment about thanking our speakers. I'd also like to thank our audience, who I know care really deeply about what we've heard about today. And thank you for coming. And it's been really a pleasure to have you. But most of all, I'd like to echo the Minister's thanks to Dr. Claire Lightoller. Thank you. You have used this you've used this platform to be such a powerful advocate on behalf of children amongst those who need that advocacy the most. And in doing so, you've challenged us in a way that compels us to see our role as champions and as advocates together on children's behalf. And you asked at the start, not just could we, you asked at the start, could we do better? And I think we've left this evening asking, how will we do better? And for that, we are indebted to you, Claire. And we wish everyone a very thoughtful and safe evening. Thank you again for joining us, everyone.